Hey everybody, this is Ryan McClanahan with historythroughcards.com. I hope you're all doing very well today. I was going through my collection as I always do, and I stopped by the T207 section of my collection. And this is one of my favorite sets from the era, from the 1910s. I do like the T205s quite a bit. I'm not really a big fan of T206, I have to say, and I know in some circles that is not very popular. But the T206 is probably one of the most influential and most heavily researched sets in the hobby, whereas the T205 and especially the T207 is not. I did do an article on the T207 and I just barely scratched the surface. I didn't get to any of the backs of this particular set, but I am doing a book on all three of these sets and a comparison to history. And the one really interesting thing I think that I did touch on in my article on the T207 is the name of Representative Thomas Gallaher from Chicago. And in 1912, he asked the question, is baseball a monopoly? I found a few articles from 1912 on this, and I'm going to read one of these articles to you guys, exactly what happened. And I think you're going to find it really interesting. 1912, the T207 set in particular, there's a lot going on behind the scenes than anybody knows. There's also a lot of things that we don't know, and there's more questions that I have that I don't think can be answered quite yet. Um, as far as the Bureau of Corporations is concerned, they're the guys who actually did the report on the American Tobacco Company and issued it to the President of the United States, which was William Howard Taft. And another copy went to the Justice Department under George Wickersham. And these guys went after the American Tobacco Company. However, that was in, I think, May 29th, 1911, when they essentially closed the book on the American Tobacco Company and tried to break it up. Now, the one interesting thing here is that the American Tobacco Company was a monopoly, but afterwards they're like, okay, how do we break up this company? You have to remember that trusts formed in 1882 and they were started by a guy named Dodd. He was a lawyer, and so he developed the trust. And by 1911, not terribly far apart, really, they really kind of had problems with trusts. Not the fact that, like, okay, we have monopolies and we have to break them up. The question before the courts was, you may have a monopoly here, but how do you actually break up a monopoly where it's not going to destroy other businesses? And it's not going to have a lot of people out of jobs. And that was one of the questions that the courts had to ask themselves. And this was actually a question that Louis Brandeis, before he was the Associate Justice, he had asked this question too. And in fact, he wrote a book prior to this about monopolies. And so they weren't really sure how to do this. And I have read extensively on the thinking of the day on monopolies and how to break them up. And so they actually found a lawyer. I don't want to bore any of you guys with this stuff, but this is one of the things that makes these cards rare. So you have a lot of cards that are rare in the T205 and T207 sets specifically. And one thing that I had thought is, okay, are these cards rare because of the breakup, or are they rare because one player retires and is pulled from production? We simply don't know all the answers yet, and I'm not entirely sure or convinced yet that the breakup itself was the reason why these cards are actually rare. My guess is that it could be. So if American Tobacco Company was a monopoly with cigarettes, they were also a monopoly when it came to tobacco cards and baseball cards specifically. And Gallagher's got a really interesting thing going on here that I want to tell you guys about, and then we'll bring it back and I'll give you my estimation, if you will. Here you go. This is from the Richmond Times-Dispatch, Richmond, Virginia, March 12th, 1912. Baseball Trust most audacious. Gallagher wants spotlight turned on national game, asks Congress to investigate. He thinks federal laws are being violated and men sold into slavery. Magnates at loss to know whether he's in earnest or only joking. Washington, March 11th. A congressional investigation of the Baseball Trust, the most audacious and autocratic trust in the country, was proposed in a resolution introduced by Representative Thomas Gallaher of Illinois today. The measure would create a special committee of 7 representatives to inquire of the Department of Justice what steps have been taken against the Baseball Trust as against other illegal combinations, and would authorize it to subpoena witnesses and employ assistants. It accuses the Baseball Trust of presuming to control the baseball game, its officials announcing daily through the press the dictates of a governing committee, how competition is stifled and games apportioned, prices fixed which millions must pay to witness the sport, how men are enslaved and enforced to accept salaries and terms to be forever barred from playing. Mr. Gallagher said the Department of Justice knew that there was such a trust under the law and that he would confer with the department in a day or two. Chicago. When informed of the Gallagher resolution, President Ban Johnson of the American League said, "We would be glad to have an investigation. There is no baseball trust, and competition is not stifled. Anyone who desires is welcome to get in the game. So far as men being enslaved is concerned, a large number of the players are drawing salaries in excess of what is paid to congressmen. That does not look like much enslavement." President T.M. Chivington of the American Association said, "Any resolution of that sort presented to Congress must be based on lack of information of the extent, purpose, and operation of what is known as organized baseball. As a matter of fact, there is no violation of federal, state, or municipal law in the operation of organized baseball. So far as the National League of Baseball Clubs is concerned, we invite an investigation," said Thomas J. Lynch, president of the league. When told that Representative Gallagher had introduced a resolution for an investigation of the Baseball Trust, he added, "There's absolutely nothing savoring of a trust in our league. We do not in any manner stifle or attempt to stifle competition. I endorse everything that Ban B. Johnson, president of the American League, says, and especially his words concerning the enslaved players. Let the investigation of the National League proceed. We have nothing to fear." Thinks it's a joke. Congressman Gallagher's resolution for an investigation of the so-called Baseball Trust was characterized as a joke today by August Herman, president of the National Baseball Commission. "I don't know what he means," said Herman, "unless it's a joke. There is no baseball trust, and from the nature of the game there never can be. The commission does not fix prices. Different prices are charged in different cities. There can be an investigation at any time without any objection from the National Commission." So I couldn't find out if this went any further than 1912. I think that What happened was he put up for a vote and it was a no-go, that they weren't going to invest any more time into whether or not baseball was a monopoly. Now, we definitely know that Oliver Wendell Holmes Jr. said that baseball was not a monopoly and it didn't violate the Sherman Act in 1922. And his reasoning was that it was not interstate commerce. Well, this is a problem because back in 1901, uh, Napoleon Lajoie, he was traded to the Cleveland Blues, and they became the Cleveland Naps, which were the Cleveland Indians, and now the Cleveland Guardians. And so the reason why he was traded in 1901 was because he had apparently violated his contract and jumped, and the Phillies claimed that he was actually property of the Phillies, and he, there's other things going on here with that, but uh, his lawyer, or at least Connie Mack's lawyer, stepped in and found a clause or a loophole, if you will, and as long as Napoleon Lajoie could play on another team outside of Pennsylvania, it would not be considered interstate commerce. I don't know how they got to that, but legally that's what happened, and he was traded because if he had played in state, it would be considered interstate commerce and a violation of that. So again, I don't know how Oliver Wendell Holmes came to his conclusion that baseball was not an interstate commerce thing. That you obviously have teams outside of, say, Pennsylvania playing baseball and they're jumping across state lines. That's interstate commerce. And so, you're getting money flowing back both, right, from one team to another out of state. So, either way, if you have two teams playing in the same city or state or whatever, and then they're flying or going by train or whatever, it's still interstate commerce. So the one thing that I think the courts at the time probably didn't understand, and as great as Oliver Wendell Holmes Jr. was as a justice, I think he was an associate justice. I think he came up in 1905, and then the Supreme Court justice. Basically, he was a chief justice as well. I'm not entirely sure how he came up with the interstate commerce clause not being effective in baseball. This is really interesting because the question is baseball a monopoly? Well, yes, I would say that back in 1911, 1912, it was a monopoly. And the reserve clause, to me, is a really disgusting piece of legislation that went through baseball as well. And that was devised by a lawyer. I mean, okay, great. And the first time that was implemented, it was in 1879, and I'm really glad that it has no place in baseball or any other part of employment. Can you imagine that your employer says to you that if you don't work for us, you're never going to work in your field again for any other company? And when you sign a contract, we can say uh, that you're going to play or you're going to be with us, and if you're not, that's it. You're no longer going to be in your field. Well, I don't know any other company or organization that does stuff like that. Maybe the military is a lot different because it's government, but even so, that to me is a very disgusting piece of employment, and players' rights revolve around that, and Kurt Flood as well. It's one of the reasons why I think Kurt Flood should be in the Hall of Fame, to try to get rid of that thing. And yes, it is a thing. It's gross. Anyway, baseball was a monopoly, but Congress obviously didn't want to touch it with a 10-foot pole, and I don't blame them. So in 1907, the powers that be decided that baseball was a national pastime, and they wrote a report. But when I was talking to the curator for the Hall of Fame back in 1999, he had said that the Mills Commission was a committee that didn't sit down. They didn't talk to really didn't talk to each other. Abraham Mills was the guy who wrote it, and the report in 1916. It was believed that it was uh, just kind of caught up in a fire. It was in a box basically until 1999 when the Baseball Hall of Fame found it. And what it was doing in the private collection of a former ball player is anybody's guess. I have no idea. Neither does anybody else. But um, I'd love to hear what you guys have to say about this. If you think that baseball was a monopoly, and there was a lot of people who believed that monopolies at the time should have been broken up in like 1911, 1912. And the problem, I think, here is that there's two prevailing thoughts in 1911, 1912 when it came to monopolies. So Louis Brandeis said before he was the Associate Justice on the Supreme Court, he wrote a book and he had asked the question, how do we break up some of these monopolies? And if you break up a monopoly, will it cause more harm than good? Some monopolies were allowed to stay and some weren't. Because again, the courts had a really difficult time trying to figure out how to break up some of the stuff. And in the American Tobacco Company's case, you have four companies that they broke up. But this was on May 29th, 1911, that that court case came down. It didn't stop there. You had a lower court having to decide exactly what do we do with the financials of this company and how do we break it up safely so that everybody who invested in the company will be able to get their money back. And then with the people that were indicted, so there were like 29 people from the American Tobacco Company that were indicted. Nobody went to jail. Only one guy died, but you had all these directors of this large company that were on the boards of, or basically the board of directors for all other sorts of companies as well. And what do you do? So they had to figure out exactly how to break this company up safely. And it went on throughout 1912. You're looking at history right here, and also with the 1911 T205s as well. And this is Huey Jennings. And I know Huey Jennings for one thing, and it's stupid. So Huey Jennings, he was a lawyer, and from what I know, he's a pretty smart guy, but he ended up diving headfirst into a pool that didn't have any water, and he cracked his skull. And he had a lot of mental health issues as well. But he's in the Hall of Fame. I actually traded another Huey Jennings card for this card, and the one I traded was I believe it was a T206, and it was in better condition than this. Sometimes you just don't care about condition. You just want the card, you know? And so I really like this card. Um, but the T207 presents a lot of issues that are really behind the scenes. And I think the T205 as well. T206, as I said before, that's a set that has been investigated up and down, and the American Tobacco Company as well. And one of the reasons why we know so much about the American Tobacco Company is because of the Bureau of Corporations did a study on this company, and they reported their findings to the president, and a copy of that went to Attorney General George Wickersham so he could go after the American Tobacco Company. But this company has been investigated up and down. There's a lot to it. It's really, when you think about it, there are 3 volumes of their report to the president. And I do have a copy of all 3 volumes. and I have an original from 1911. It's volume 2, but it's just, again, voluminous. There's so much there, but it doesn't really say a whole lot about the cards. It says about the tobacco, how the tobacco company ran its business, how it hid other businesses, and really who was involved in it. So it is something for a historian. There's a lot there, but for a historian who specializes in the hobby or in sports cards or the T205 and T206, 207, you have to still kind of piece together these things and try to see if they fit. And sometimes it just doesn't work out the way you thought. And there's a lot of dead ends here too. And the other thing is the T205s and T207s, especially, they're not well researched. The backs, the brands, they're not well researched. The first serious researcher, I think, was a guy named Heitman in 1980, Bill Heitman, and he was the first one to correlate the rarity of the backs with the cards, and it was really kind of an interesting thing that he did because prior to this, you didn't have anybody researching the rarity of these cards or the backs of them or the brands or anything like that. What I think is um, associated with this is another case with the Federal League. I think it's directly tied to monopolization in baseball, which the belief there is that this carried over to the Federal League case and the Baltimore Terrapins lawsuit of Major League Baseball in 1916. And I think this actually turns into the Oliver Justice Wendell Holmes Jr. case from 1922, where he says that baseball is not a monopoly, or it's tax exempt from the Sherman Law. So the Sherman antitrust law is really interesting. It was actually fortified in 1914 as the Clayton Act, and you really kind of like need to dive into some of this. And I will actually tell you guys more about the Sherman Act and the Clayton Act because I think actually there are a lot of monopolies today, especially the tech monopolies that have not been broken up. And I think the last tech monopoly that was broken up was Microsoft in 2001. So monopoly cases take a very long time. In 1911, the American Tobacco Company case that actually was initiated in 1907. I could probably talk your ear off about this forever because it's something I'm really, really interested in. But for the average collector, they're probably like, no, I don't care. The thing is, if you want to know why some of these cards are rare, you have to look at other things other than the player or the card itself. A lot of times, the reason why the card is rare is because of what's going on in the economy, what's going on in the health of the company, and maybe sometimes the advertising itself, or if it's a regional issue. The T205s, T206s, and T207s were also regional cards. They were not mass produced throughout the United States, and I'll get into that in either another video or part of my book. I've already actually said a little bit about this in my look into the T206. But guys, thank you so much. I really appreciate it. I'd love to hear what you guys have to say about the T207s. If you have any favorite T207s, I do. It's a very interesting set because you don't have a lot of name players, not a lot of Hall of Famers, although the Hall of Fame wouldn't have been announced until 1936 anyway. So, in 1912, it doesn't really matter. Some of these guys were, your average everyday in or out players. They just carried on and they played the game and then they left for the day, while others were superstars. You don't have a whole lot of superstars in the T207, and a lot of people have asked why that is. I'll get into that as well, but Again, I love the T207 set. It is something that reminds me of not just baseball, but history, because you are looking at history here. Anyway, guys, thank you so much. I greatly appreciate it. I could rant on and on and on about this stuff because I love it, but I don't know if anyone else does. But anyway, guys, I'll talk to you later. Have a good one. Bye.